Employees will inevitably irritate each other at times. What happens when that irritability becomes something bigger and there are two or more employees who simply cannot work together any longer? Can you dismiss? And if so, who should you dismiss? In this video, I'm going to discuss which employee to dismiss, what happens if someone is unpopular with a large group of colleagues, how to articulate the reason for dismissal, when the relationship isn't retrievable, the problem of victimisation, and 7 things to do if a relationship breaks down. For a dismissal to be fair, there must be a fair reason and there must be a fair procedure. The reason is most likely to be conduct or some other substantial reason. It'll be conduct if the employee has done something to provoke the breakdown, such as bullying a colleague. It will be some other substantial reason if the relationship has simply got to a stage where it can't continue. In Simmons and Salisbury NHS Foundation Trust, the employee was a trainee medical photographer, and her working relationship with a senior photographer had broken down after he had bullied her in the workplace. The senior employee was issued with a disciplinary warning, and the junior employee was off sick for some time with anxiety and depression. When she returned, she couldn't work with the senior employee, becoming distressed if he entered the room. She wouldn't engage with mediation, although the senior employee would. Eventually, she was given the option of resigning or being redeployed. She asked for a job with no contact with the senior employee, but as this wasn't possible, she was dismissed. And the Court of Appeal found the dismissal was fair. It was noted in particular that 2 years had passed since the end of the bullying and her being dismissed. The senior employee was keen to rebuild the relationship, but the junior employee said it wasn't possible. The situation had gone on for so long that there was no reasonable prospect of it being resolved. Now, in some situations, it might be appropriate to dismiss both employees when a relationship breaks down, but if one employee is willing to try to repair the situation and the other isn't, dismissing just the one might be a fair solution. A breakdown in relationships isn't necessarily between just 2 employees. It could be a group of employees who are protesting about the actions of a colleague, as happened in Esaias against North Glamorgan NHS Trust. Mr. Esaias, a doctor, was openly critical of management and openly critical of his colleagues' competence. Now, these colleagues became so frustrated with his behaviour that they signed a petition and submitted it to management, asking for Mr. Esaias' dismissal. After a lengthy investigation, he was dismissed. Now, he raised 75 points at the Employment Tribunal, all of which he categorised as protected disclosures, as whistleblowing disclosures. The Employment Appeal Tribunal agreed it was a fair dismissal, and the 75 points were complaints about colleagues and weren't protected disclosures. The number of disputes was so great that it wasn't realistic to think the relationship could be repaired. Now, although pressure from colleagues won't always be a reason to dismiss, if the working relationship has broken down irretrievably, it can be a potentially fair dismissal. In this case, the dismissal was for some other substantial reason. It is important to be clear about the reason for dismissal because this could determine which procedure should be followed. So in the Esaias case, which I've just mentioned, the employee argued his dismissal wasn't fair because the contractual disciplinary procedure relating to misconduct hadn't been followed. The employer successfully argued that the reason for dismissal was some other substantial reason, and therefore there was no requirement to follow a dismissal procedure that existed for misconduct. A relationship might have broken down, but before dismissing, the employer must reasonably conclude that it can't be repaired. So in a case called Phoenix House against Stockman, a restructure resulted in the employee's job being removed. Now, she applied for 3 new jobs, but was only offered the most junior position, and she argued that was because her line manager disliked her. She confronted the manager, raised a grievance, and was then absent due to sickness. On her return, mediation took place, but her employer concluded that the relationship had irretrievably broken down, and the tribunal and the Employment Appeal Tribunal concluded the dismissal was unfair because the employer had required the employee to disprove that the relationship had broken down irretrievably, The employee hadn't had an adequate chance to argue her case or to challenge the allegations made against her, and it was outside the range of reasonable responses for the employer to conclude that the relationship had irretrievably broken down. It's not enough to conclude that two employees are not getting on. For a dismissal to be fair, the relationship must be at the point of no return, with no reasonable prospect of the employees being able to work together again. A relationship might break down because an employee is seen as difficult or because they keep raising concerns or grievances. Now, if the matters they complain about relate to discrimination, a dismissal could amount to victimisation. In a case called Woodhouse against West Northwest Homes Leeds Limited, the employee raised 10 grievances in a 5-year period, all alleging race discrimination. He was dismissed on the grounds that raising these grievances demonstrated he'd lost trust and confidence in his employer, and there was no possibility of a sustainable working relationship going forward. However, the Employment Appeal Tribunal found the employee was dismissed for making the discrimination allegations, and this was clearly victimisation. He was also successful in his claim of unfair dismissal. What then should an employer do if the employment relationship has broken down? 7 suggestions. Number 1, don't leave the relationship to fester. A common theme where relationships have broken down is that they could have been resolved had action been taken earlier. Address the problem, seek a solution, and try to prevent escalation. Number 2, be open and frank with the employees involved. Sometimes they just don't realise the impact their behaviour is having. An informal discussion and using mediation where appropriate can be a way of resolving issues before they become irretrievable. 3, identify what's behind the problem. If action needs to be taken, explore the reason why. Is it one particularly difficult person, or is it just a clash of personalities? Is there something going on in the background? An employee who is underperforming and frustrating colleagues, perhaps, or someone struggling with ill health of which colleagues are unaware. Number 4, don't be afraid to confront whoever is at fault. It's highly likely they're not going to be a particularly easy character to deal with, but the situation still needs resolving. Resist turning a blind eye because the problem's unlikely to go away. Turning a blind eye now could mean a substantial compensation payment later. Number 5, if dismissal is the answer, identify the reason. Now, this is key to ensuring the correct procedure is followed and to making sure the dismissal is fair. Does the issue centre around poor conduct, or is it some other substantial reason? 6, follow a fair procedure. The reason for dismissal might dictate which procedure is followed, but there's an overarching need to treat the employee fairly, however difficult they may be. Now, this means allowing them the opportunity to put their side of the story and making sure the employee understands the impact that their behaviour is having. Finally, 7, dismissal might be the answer, but it's not just the employee causing the problems who needs to be treated fairly. If the behaviour is upsetting colleagues, there is a risk they will go off sick with stress, and then you have another issue to deal with. Sometimes the only answer is to dismiss the employee causing the problems. Thank you so much for watching this video. If you found it useful, please subscribe to this channel. You can subscribe down there. These are some other videos on employment law, and here are some videos on consumer law. I'm Barrister Daniel Barnett. Thank you for watching. Bye-bye.